it's very easy to kind of kick cans down the road. And I understand sometimes you have to. But the goal of your business is probably either to get investors or get a buyer, right? At the end of the day, it's probably what you're trying to do. And so pretend as if you're doing that transaction now, and you're going to have a lot less problems down the road.
One important shift that I see a lot of new managers struggle with is the fact that they are now the face of their company for their team. They set the tone for whether or not people follow the rules, namely compliance rules. In today's episode of the Leadership Launchpad, I am talking with Shawn Cheadle and John Gordon, attorneys in the Aerospace and Defense Practice Group of Taft, a full-service corporate law firm with over 1,000 attorneys nationwide. Shawn is a partner in Taft's government contracts, export controls, and international trade compliance group. Before he was at Taft, Shawn spent 15 years as in-house counsel at Lockheed Martin Space in Denver. John is a venture capital and commercial contracts attorney focusing on space startups. He is a frequent speaker at Purdue University's Aeronautical and Astronautical Engineering Department and serves as a mentor for Techstars Space Accelerator. I'll admit this episode may sound a lot different than most of our episodes. We're not talking about core leadership practices, but I promise you it is worth it. By the end, we really identify some simple frameworks that every leader needs to use to make sure their team and their company is safe from losing contracts, getting large fines, and even facing prison time. If this is your first time listening to the show, make sure you hit subscribe so you never miss a future episode. And if you are responsible for developing leaders in your organization, then I want to talk to you. Please reach out to Matt at bettereverydaystudios.com so we can see if there's any way we can help make the leaders of your organization better. With that, let's get into the discussion. Shawn and John, welcome to the Leadership Launchpad. How are you both doing today?
Doing great.
Great, Matt. Doing good. Thanks
for having us.
Awesome. I'm excited to have you both. During the intro, I kind of told everybody this was going to be a little bit different. We're not necessarily talking about the core concepts of leadership, but instead we're talking about some really important information that I think a leader at any level, whether you're a frontline manager all the way up to leading a company, really need to understand. Since we are going to be talking a little bit, about some legal topics here. I know there's people are going to want to know why they should be listening to you. So I'd love if you could each give a little bit of your background, and then at the same time probably provide some of those legal disclaimers to make sure you're not, you're just giving your opinions, I would guess. So which one wants to go first, Shawn or John? Who wants to start us out?
I'm John Gordon. I'm an attorney. I'm an associate attorney at Taft. I work in a corporate group. I mostly do venture capital and emerging technologies work. Got plugged into the industry through Purdue University, so doing a lot of their aerospace engineering students and spinoffs wanting to do, especially in the launch and propulsion industries. Yeah. So do a lot of work, but a lot on the young company side and on the corporate and commercial side. On top of that, I'll just say, like we always do, we have to give our lawyer talk. Anything we say, it's not legal advice. Talk to your own lawyer. Also our opinions are mine and Shawn's are not necessarily Taft's as well. So, Shawn's resume is much more impressive than mine. So I'll let him take it.
Well, I'm still building it. I spent 27 years in-house, Matt, and, as counsel to small suppliers, mid-major suppliers, I would call them, and prime contractors, world's largest defense contractor, Lockheed Martin Space. Legal. Yeah. So, but I'm doing what they call a reverse commute in law, where I go into private practice. And it's been a great opportunity to now work with so many of the suppliers that I was across the table from for years, right? So helping them in areas of law that are very complex and confusing and sometimes expensive. But we make it quite affordable being at Taft. It's incredible rates. compared to what I used to have to pay at Lockheed Martin, for instance. But like John said, we both practice space law. But I do a tremendous amount of government contracts. I work in obviously the aerospace defense sector, which can lead into security clearances and counterfeit parts, some of the regulated areas that we do deep dives in. And there's a ton of compliance, which we'll probably get into. At a large company is very different than small company. Hopefully we can talk a little bit about those differences. And then in this mix, there's the international trade piece, right? Tariffs is top of mind to everybody right now. However,
Yeah.
Just to be in the industry, you've got to really understand your export control regimes, and
Yep.
that's the Export Administration regulations under the Department of Commerce, and the International Traffic in Arms regs under the State Department. So ITAR, as most people know it, and
Yep.
so that's a big mix, and you do everything else an inch deep, right? And we have
Yeah.
experts across the firm that really support us in a lot of areas like foreign control, foreign ownership, if you're doing a CFIUS review. And I have a quality background as well, so companies that are doing AS 9100 certification,
Yeah.
there's so many swim lanes to watch out for there. You could call it compliance, but a big one is data management, because a big requirement of
Yep.
AS 9100 is having to do traceability all the way down 5 tiers through
Yep.
suppliers if you're a prime. So it's it's behooves the engineers and managers to understand their data, mark their data. That's something John and I do tremendous amount of. So I think when you mark data and manage it, you grow. So anyway,
Nice. There's so much there, and you're really speaking my language because, obviously there was lots of compliance that was kind of invisible to me when I was in the military because it was just so baked into the structure. And then as soon as I got out into the corporate world, so much of my time in training and development has been centered around compliance, and especially as you get into the hardware world, I gotta believe that's one of the big differences between the speed and pace at which the software world has been able to move versus hardware, at least in the United States, is just the level of complexity of whether it's export compliance, whether it's traceability is a huge thing. There's just endless rabbit holes that you can go down on compliance. I would love to start with something you mentioned there, Shawn, of the differences in kind of large companies and small companies. I think one common thing that, at least here in the States, there's certain levels of companies that don't have to worry about certain kinds of laws. And then as you grow, they have to deal with other kinds of laws. But just since you've worked with such massive organizations, speaking to a manager, or somebody who's maybe going out to start their own company, maybe they're leaving a major firm. What are some of the differences in the kinds of support that leaders can expect regarding compliance at a major a company like Lockheed Martin versus a smaller company?
well, I think at the outset you realize you're starting with a blank slate at a small company, right? You've got no
Yeah.
policies in place whatsoever. You have no training matrix, and no training history. You don't even have a document control plan, much less a way to manage, which version of compliance policies you might want to implement. At large company, you've got someone else largely doing that for you. As a lawyer, I represented a policy making group at Lockheed Martin, and they were off all the time revising, updating policies to regs, and small companies don't have those resources. So it's if you're going to start from scratch, I call it the dirty dozen number of policies that you ought to really put in place. A lot of companies don't do that. They're really worried about finding funding, which John can speak to. It's really difficult for them to spend a lot of time and effort on paperwork and training for something they don't even have their first contract, right? And peace
Yeah.
on that. I understand if you're going to start in the garage and develop product, that's one thing. But when you go to market, now's the time to think about what is the suite of areas that I need to be focused on. As a small business owner, what's their C-suite look like? And I think a part of that should be compliance.
Yeah. kind of going off of that, John, like to this idea of finding funding, because yeah, like at first you need something, you need to get started. When does the lack of or the amount of kind of controls that you have in place as a company start to impact funding? Like I would imagine at some level people don't want to sign a check or they don't want to sign a contract if they don't know that kind of you've gotten your ducks in a row when it comes to some of these compliance issues.
Yeah, no, that's a great question. And Shawn spoke to it, but I mean, the issue at its core when we deal with a lot of the startups is like founders, even if it's a small team of engineers, they're wearing 100 hats. Okay,
Yeah.
so at your big companies, like there's someone for everything. There's
Yeah.
someone for compliance. There's someone for HR. There's someone for, and there is, you're it. And so that becomes difficult when you have, a compliance lawyer telling them this is your most important issue because it is their most important. It's that lawyer's most important issue.
Yeah.
But to
Yeah.
the CEO, they have about 14 different most important issues. So they're just trying to juggle everything and make payroll on Friday. So
Yeah.
they have to make that decision about, when do we transition into a more structured compliance regime? So I've seen it come up in a few ways. So if a founder takes like a safe, which is like a pre what they call a priced round fundraising, so basically just like a future agreement that I'll just hurry up and Y Combinator came up with it says I'll hurry up and give you $500,000, and then whenever you do a round later, just throw me in there, right? It's kind of basically
Okay.
what it is. Um, Nothing really comes up there because those are designed to be very surface level and very like early stage.
Yeah.
But if you go into doing what's called Series A, then you start having like your due diligence, right? So that can come up, and you can have reps and warranties in your agreements that basically the company's promising the investor, hey, like we don't have any ITAR violations. I promise that we don't.
Yeah.
So that can come up, and they might not even know. More often than not, I think I see when these companies are going after SIBRs, so they're going after these
Yep.
small government contracts. Well, then the FAR or the DFARS kind of rears its ugly head, and they're like, "Wait a minute, like what is this? What is all this? Like, how am I supposed to comply with this or comply with that?" And so yeah, so then obviously like at that point, so either like doing like a price like a Series A or going after like a SIBR, those two periods usually come or stitter, but like both those periods kind of are when it can arise. But then they still have to make those decisions, right? So someone like Shawn would come in and say, well, here's all the things you need to do. And sometimes they have, just say $50,000 worth of things they need to do, but they only have $10,000. So now they got to start making decisions about, what to prioritize. And that's just always the juggle of the founder. Now there's
Yeah.
always, they'll reach that stage where they have, all the right levels of compliance they need, but it's a guessing game about when to make those transitions. So any lawyer will always say earlier the better, but the founder is the one that has to make the call about looking at your P&Ls and saying like when can we afford to do these things.
Yeah.
um, yeah, and that's just kind of what makes it's like a chicken and egg problem for space companies, right? Because the big
Yeah.
companies have all this compliance regime to get all these contracts, and you can't get the contracts until you have the compliance regime, but you don't have the money till you get the contracts. So it's a tough thing.
I mean,
If I
it's
could add, Matt, I would be careful about guessing as to what doesn't apply and what does, or what can you get away with versus what you can't. You may have to certify with some subcontracts six or
mm-hmm.
seven areas of the FAR and the DFARs. And if you have to certify, now you could have a fraud issue, right? If you've taken on a regulation and say that you're compliant and said, yeah, verily I've certified to that, and then you're caught not being certified or compliant, that's a problem, right? So
Yeah.
you got to really get some legal support on that, right? How are you
Yeah.
going to implement, to John's point, and right size your compliance model?
Yeah. Before a couple terms have been thrown out there that I want to make sure everybody understands. So I think the main ones that came out were SIBR, FAR, and DFAR. What can you describe those for the audience, for anybody who's not aware of what those are?
I think I popped them off, but I'll let Shawn explain. That's my role. I just say things and let Shawn explain
Yeah.
it later. Okay, go
So
ahead.
let's talk small contracts first of all from the government.
Yes.
There's an OTA, which is another transactional authority. That actually does not have FAR and DFARS flow down to it. SIBR, Small Business Innovative Research Contract, that can be flowed down. And then there's SITR, which is now escaping me. STTR is the acronym, but it's also a small technology
Yep.
research contract. And the FAR and DFARS do flow to SIBRs and SITRs. FAR and DFAR stands for FAR is Federal Acquisition Regulation. That's singular, so you hear FAR. DFARS is the Defense Federal Acquisition Regulations Supplement. That's why the S is there. NASA has a very similar NASA FAR supplement, right? So we call it the NFARS. And you may find three-letter agencies with similar regs, but they all kind of mirror each other, starting with the FAR. The FAR has 53, 52 parts that you really need to be mindful of. So it's a big bucket of compliance to go exercise your implementation of regulations into your shop, right? And really understand how
Yeah.
that impacts you on just three small types of contracts. So
Yeah, you really can't overstate the challenges that can kind of come into play the moment you decide to sell to the federal government, and bring them on as a client, because the level there's obviously all the the standard compliance that is there for any company doing anything inside the United States. It doesn't matter who you sell to, you have to follow OSHA guidance, and things like that. But then the fact that you become a seller to the federal government, or to often any government, just from my time inside of Space Systems Command and kind of seeing this from afar, it is, SIBRs, SITRs, like so many of these things are newish programs that were designed specifically for the fact of the government wants to get smaller companies in on government contracts, and they can't figure out how to do it. Just traditionally, because the big primes had so much of this infrastructure to navigate the FAR. They needed some, and navigate just different things. They needed some new ways to get people in, and so it's really a challenge. I guess one question that comes to mind to me, that might come to mind to a lot of people, is like, these are regulations that are written down somewhere. Why isn't there just a simple solution? Why can't somebody like a group of lawyers like you, just say here you go, here's your compliance answer? Why does it become so difficult and seemingly so bespoke almost?
well, that's a good question, Matt. It's we've been asking the same question for a long time, and I was in front of a lobbying consultant last year in Washington D.C. who said, if we're going to rewrite the FAR, we ought to put you on it, and they were pointing at me. It's like, I know a lot. I'm pretty dangerous with it, but it is a big bucket of regs to decipher. To your point about a matrix, part of the challenge with the FAR is that it covers every contract type. So you have cost plus, or cost reimbursement, some call it. You have fixed price. You have fixed price incentive fee or incentive firm, some call it. You have level of effort. You have indefinite delivery, indefinite quantity, which is IDIQ contracts, and task orders let thereon. So all the regulations govern all these contract types. And some are a blanket across all of them. You got to have a business code of conduct, and there's a FAR provision for that. So you might as well have a policy right at the outset on business code of conduct. But you can actually simplify and figure out a matrix, right? If you're on a firm fixed price basis and you're selling COTS materials, very, very few FAR are actually going to implement and affect what you're doing. When you start growing up in the industry and you get bigger and bigger contracts, there's a lot of dollar thresholds that trigger inside the regs. So you get, if you're below $250,000, for instance, you're under the simplified acquisition threshold, or SAT they call it. You get above that, now certain FAR provisions are going to start kicking in at dollar levels, right, as to when it applies and when it doesn't. So you might see 50 or 70 FAR regulations float on a contract, And if I were to go through it for you, I might tell you that 15 are actually going to apply. Maybe there's 50 that apply, but only 15 are really going to change what you're doing, or you're going to have to watch really closely. The others are going to go on by. Many of them will self-delete, as we say, right? You keep them on the contract just in case. What you want is an amendment. You get an amendment to the contract, that's more money. Those clauses will suddenly trigger, and things like that. Now, the FAR also has a matrix in sort of the back end of the FAR in Part 52, I believe, but it tells you whether something's applicable or absolutely mandatory. Applicable can be, it's applicable when it's applicable. If the dollar thresholds trigger, there's a prescription to each regulation. If you go look at the prescription, it may tell you whether it applies or not. It doesn't actually apply to fixed price contracts, it might say, so don't worry about it, right? The DFARS does not have a similar matrix. But it does have the similar application to various contract types, except for a few big areas, and that is counterfeit parts compliance and cybersecurity. Even small suppliers are stubbing their toes on cybersecurity, so it's having to get to what's known as the cyber maturity model certification, or CMMC. That's impacting machine shops, mom and pop machine shops, right? So many of which don't have the ability to become NIST certified in their cyber hygiene. So those DFARs are very real and critical to manage first, I would say.
Well, I'm hearing a lot of, it just sounds like there's a lot of different ways that companies can evolve, that contracts can evolve, and so that just kind of necessitates a lot of complexity. Interesting. Regarding going back to kind of those early days, like as a company's starting to grow and all these different these different compliance regimes are starting to apply in different ways. Just to give a sense of how this looks, I think when we talked last, John, you mentioned that there may be, are there any examples that you've seen of where not having enough guidance in place either kept a company from getting funding or maybe caused problems for an early company? Like, how do we make this? Because I think a lot of times when we hear all these rules and if this happens then this could happen, and it's almost just like too hard to even imagine. Like what's some practical examples that somebody can latch onto?
Yeah, I would say, like, practically speaking, as someone who represents a lot more of the early stage startup end, simply not convincing either government customers or primes that you're trying to sub for that what you're talking about and what you're doing can cost you contracts. So I've had clients, in talks with like primes to be subs.
Yep.
And basically the primes were not convinced that they had, even though they didn't have any violations, like they didn't have any issues like that. The prime was just not convinced they had the compliance know-how they needed. And that just made them too nervous, and then they lost it. So I think not even necessarily having obviously the violations become problems.
Yeah.
And you have that stuff, and but yeah, I think just how it's conveyed to either government customers or primes you're trying to get in with, that you have that kind of organizational maturity, I guess I should say, that could cost you.
That's really interesting, and feels like a really practical takeaway. Somebody, because it's on the leadership development side, a big part of what I do with teaching engineers to be managers is convincing them that the people side matters. You went to school, you got your degree, you've done all this amazing technical work designing components or systems or whatever it is, and it's kind of saying like, that's great, I'm really happy you did all that. There's this whole other bucket of skills that you now need to transition into in order to be a successful people manager. And to me, just kind of that realization, this is another thing, can really open the door to just knowing that you need to learn that stuff. It sounds like you're almost saying something similar just in the compliance realm of simply recognize, what a person needs to do, whether they're, a new founder or an early stage employee, is to just have that realization. This is a serious thing, and I should probably take a little bit of time to get smart in it. I don't need to get a law degree. I don't need to become an expert, but
Sure.
I need to be conversant in it and knowledgeable about the repercussions if we get it wrong.
So,
Sure.
Matt, this is a great topic, I think, for engineers to really understand. When I think most engineer, I've worked with thousands of them, they could all do a bill of materials, right? They could all show me
Yes.
what goes into a bill of materials because they're
Yes.
building product, they're building whatever, even software. But if you're thinking about a bill of materials, and you made a point just a second ago about leadership starts with people. If you put labor and employment on your bill of materials, if you put compliance, if you put legal, right? No one thinks of that. They think of it as overhead. Well, then they forget about overhead and then they just start building product. Building product
Yeah.
means add these other items because you got to treat your people right under labor and employment regime. You've got to be
Yep.
compliant to get your contracts, right? And include legal where you need to turn the dial a little bit, right? Course correction
Yeah.
can be incredible, as we know in space. You want to hit that reentry point, you got to have a little course correction, not a lot sometimes.
Yes.
And that can be worth its weight in gold as a bill of material line item. And if you think of it that way, I think you're going to have a better product, a better system. You're going to treat people better, and you're going to be compliant.
I love that. I really like that. In fact, it really resonates with me as a small business owner myself, and thinking about pricing for my services that I'm offering as I'm trying to grow. Because, and you're right. And I think a lot of this has to go with the idea that so many people, as we move forward in our career, I mean, we used to say this in the Air Force, we said it all the time. We say, every leader is trying to do their last job. And what that meant is, every group commander was trying to be a squadron commander. Every wing commander was trying to be a group commander, because you're in those positions for 2 years. And so you come in, you become a squadron commander, you figure it out. Right as you're getting good at your job, you get transferred out. And then you become a group commander, and you don't know how to be a group commander yet. So you pretend you're a squadron commander for a little while. And then right as you start to figure out the group commander role, they move you out. And I think that's true everywhere, where when you're an engineer who's used to focusing on the individual components of a thing, you move up a level to where you're thinking about more the system or the entire group of people. It's about changing that mindset to remember all of those other things that at the lower level, and this is why I'm really glad we're having this conversation for our particular audience, because it can really help prepare you as you get ready to move up to that next level of, oh, these are the considerations that I need to have as we get to those other levels. And then even before you get there, just kind of having that, I don't want to call it humility, that understanding of what's going on at the higher levels of, oh, this is why we can't do it this way, or this is why we can't move quite as quickly as we can, or this is why the pricing ends up being this, because there's just all these other layers beyond the individual widgets that are going into the machine. There's other things that need to be factored in. I love that. What about, again, speaking to kind of the general manager, I think especially in kind of the manufacturing world, the tech world, OSHA is the requirement that probably hits people in the face the most, like it's the one that's right there that everybody can interact with. And we can talk about OSHA or other things, again, to like make this real. What are some examples of how companies can get in trouble and what getting in trouble can mean? I remember just recently I was making a training on export compliance, and it mentioned one of the things that I learned through developing that course that I had not heard is that relatively recently, I think RTX was hit with like a $24 million fine, I think it was, for an export violation. That's a lot of money. So obviously if people are getting hurt, and that's a serious issue. But even outside of people getting injured, what are some other common problems from like an OSHA perspective, and what are the impacts that can have on a company?
Yeah, so I'll say a little about OSHA, and then I think there's maybe the topic of employment that I think Shawn can talk a little about too. So I'll preface that by saying two things. One, Taft has an amazing employment and OSHA practice, and I'm not one of them. So if
Great.
my clients had an OSHA matter, I'd kick that thing over that way. Two, my wonderful wife, she's a kindred spirit of yours, man. She does training for a public company in OSHA and EPA, so that's what she does.
Yep.
So I know that for us, it's like over 10 people. In a nutshell, for OSHA, a lot of things have to start going on paper, and you can't just say them in like 8 a.m. meetings anymore, right? So it now becomes a requirement that OSHA will come in and say, I don't care that you've trained your employees on something. I need to know where your written policy is. So there becomes a lot more things under OSHA where you need to have written plans once you get over that 10 employee threshold. So for us, that's kind of the marker. So 3, 4, it's quite a bit looser. Once you hit that 10 mark, you kind of start having a lot more. And that's just on the small company side. We also eventually run a lot into like employment stuff, right? So that's something in due diligence. They want to know, are there any claims from past employees? Have all of your employees signed confidentiality agreements, trade secret agreements, IP assignment agreements? Like those are all things that can get them in trouble as well. And then I'll let Shawn kind of speak to like the bigger companies and some of the issues they have there.
Well, I would just, as a segue, I would add that if John and I walked the floor, manufacturing floor, as lawyers, we're taught to issue spot, right? So I'm seeing images, and these images tell me something. And if I'm seeing electrical cords, scrambled across the floor, I'm looking for trip hazards. I'm looking for hazards on a workbench. I'm also thinking AS 9100, right? Do you have wrist straps? Are you grounded? Or do you have other ways of doing that? And the other piece to that, John mentioned EPA. A lot of small companies are going to be challenged with controlling their hazardous materials. You've got alcohols, you've got all kinds of stuff, right? So a solid plan going in, and even if you're an engineering manager converting, like you said, moving up and not thinking like you used to, and now you're thinking like, a shop floor manager. What is a shop floor manager looking for? They got a dozen compliance areas they need to worry about. And as a manager, you should be too, right? Because those things are going to come across your desk if you have a slip and fall, an injury, a spill, and worse, a spill you didn't manage right? So, but all of that is layered by employment and labor law. Really understand the 3-page thesis of how to get through labor and employment effectively. How do you manage people? Think about all the training you get in a large company on being a manager, being a leader. The ways that you overcome bias, for instance, right? These are things that should be ticking through your mind at all times. And some people are really natural at it as they walk through the shop floor. And I use that metaphorically. It could be the cubicle floor. It could be wherever. It could be the hallway, right? It could be the lunchroom.
Yeah.
Hazards happen to us everywhere as employers. And so how are we treating our people? How are we taking care of them physically and also, I would say whole body. So it's that, as John said, turns into paperwork. It turns into policies. It turns into training regimes. And we're just tip of the iceberg here if you're walking the floor, because there's so many other policies to talk about for managers to understand, right? So it's but it's a real easy metaphor to think about physicality. And in our world in space, you worry about suspended loads. It's regulated. How much body can be under a suspended load? What is the load, right?
Yep.
So it's an area that small space companies really stumble across and need support on, because they don't want an OSHA violation, right? It's costly. It can shut you down. You lose time during those things. And you mentioned the RTX. There's a consent decree behind that too now. Now they have this compliance team they have to retrain their people, and now it's top of mind.
Yeah.
Should have been anyway, right?
Yeah.
And one bad actor can cause the whole corporation to now have a consent decree that might last for 10 years.
Yeah. It's interesting just the way this conversation has gone, I think can be so helpful for managers listening to this because so often compliance, like I said earlier, it's this out in the ether kind of thing that we're not quite sure how to make it grounded. And really it becomes grounded in three basic ways. Each becomes more and more practical for the individual. Of first, there's just it sounds like the first layer is just like policies. Like very quickly, you have to have company policies and procedures that are how you are going to meet these regulations. And that's like the kind of the first thing that organizations just need to make sure they're developing. And they're probably not going to be able to develop them on their own. They're going to have to work with somebody like you in order to make sure they navigate this labyrinth of regulations in the right way and they have a solid plan in place that meets those regulations. And that's great, like at the organizational level. But then I think when it comes to the individual level or the manager level, whether you are the founder of a company or a manager, individual manager inside a larger organization, there's the mindset piece of just realizing that this exists and realizing that everything you do and look at has to be filtered kind of through this lens, if you will. And just that awareness from a mindset point of view is really critical. And then the final thing, again, as a leader, and I love that you brought this up, Shawn, because ultimately it comes down to practical day-to-day realities. And that's where it all comes from. And so is it the worst thing in the world if there's a bundle of cords off to the side that hasn't been taken care of? Maybe not, but it is indicative. The fact that it's there is indicative of, could be indicative of a wider problem. And so just like John, you were mentioning when founders are talking with, they're trying to become a subcontractor and they just can't quite convince the prime that they know what they're talking about. That's the same thing that whether it's you as lawyers or regulators are seeing when they're walking around, they're seeing these things as indicative of larger systemic problems. And so it's those are kind of the three things that you have to keep in mind as a leader. Do we have policies in place that address these things? Are the mindsets there to support those policies? And then are those mindsets translating into the day-to-day activities that we either are or aren't doing in order to support those policies? Does that sound like a good summary?
That was a great. I could not put it better. I don't think. I'm not going to try. So
excellent. Well, as we close out here, gentlemen, is there anything we didn't talk about? Like, are there any other final things that you want to make sure to get across to new managers within these organizations or people looking to go out and set up their own shop from your seat of consulting with all of these different people? Any other final words?
My final is always coming from a corporate lawyer doing either venture deals or M&As. Your business gets acquired. Either one of those, you're going to do due diligence. Act like you are going through that due diligence since day one, and you're not going to have any problems. I always say that. So you just kind of, it's very easy to kind of kick cans down the road. And I understand sometimes you have to. But the goal of your business is probably either to get investors or get a buyer, right? At the end of the day, it's probably what you're trying to do. And so pretend as if you're doing that transaction now, and you're going to have a lot less problems down the road.
In the flying world, we always used to say, if you're ever going to make a decision that's outside of the checklist, just ask yourself, what will you say at the accident investigation board?
Exactly. What will you say during due diligence? That's a great one.
Yeah, awesome. That's great. Shawn, what about you?
Yeah, I guess I would add in some that let's compare and contrast for a minute. A small organization versus what I had to do at Lockheed Martin as a lawyer, executive, and I was a director for one of our wholly owned subsidiaries. I had to take 100 training courses every year, online, 100 different modules, many of which were related, right? But If you're a small company, I would say there's a dozen or so that you ought to have in place from the time you open your doors. And if you do, to John's point, you're going to scale right. You're going to meet diligence correctly. And that's a good list to understand, right? And then you can grow exponentially from there and add more policies. But part of what I see small companies stub their toe on is too much development. They spend all their money on, trying to move parts, move money. And this cloud of compliance is hovering and waiting. And when they start getting those contracts, which are lucrative and can be great, profitable, cash flow streams, then it's too late to have already started the compliance. So to John's point, foot stomp compliance is part of what it takes to spend your money on development. You're developing a corporation. You're not just developing product or services or software. You're developing a corporation, right? That has a success endpoint, perhaps, to John's point, whether it's M&A, a liquid event, or whatever, IPO. So too much development. If you're developing, develop the corporation. And that really includes this cloud of, maybe the first dozen compliance policies. I think it will grow faster.
I can't let you leave since I meant to ask you this earlier, but you've mentioned it a couple times. So what is this dirty dozen? Like what would that list be?
Let's start with a code of ethics and business conduct, because that's in the FAR. And every company should have some level of ethics policy. I would then add an employee policy. You should have a delegation of authority. Can the president sign? Can a VP of sales sign? Who can sign your contracts? Can an ops person sign your floor shop POs? You've got a lot of parts, a lot of stuff to buy in a small corporation. You've got to protect your data. You need a data protection policy. You need a contracts policy and a procurement policy. That is customer side versus buy side. The buy side's important, especially for electronic industry where you have a counterfeit parts compliance initiative. Then I have what's called the anti-policies, right? Antitrust, anti-bribery, anti-corruption. These can be, big sections in an employment policy, but you need to be able to point to them if you get into harm's way. And your folks need to be trained to them, especially anybody who's traveling internationally, right? And understand what contracts look like. Some of your contracts folks need to understand what an anti-boycott clause looks like if someone's trying to boycott Israel, for instance. That's a real problem. I mean, you're actually supposed to report it up through your contracting officer. You need an export control policy. Even if you don't think your parts are ITAR controlled, you're probably going to have export controlled information, ECI, coming through your shop. Every person on the team needs to be trained to understand how not to disclose technical data as it's defined under ITAR and the EAR. Even an administrator could say something on a phone and it'd be a deemed export, right? And then you can go into security policies or environmental policies. So that's a good start, right? If you did that, and some of those are pretty technical, but they're all nothing more than 5-6 pages for an early startup, and you just right size it, and then you train to it, and then you have a training matrix because people come and go.
Yeah. Well, there's nothing I like more than ending the show by giving our listeners a bunch of homework of what they need to go figure out. Either they're going to put into their own company or see if their company has it already for them. So, gentlemen, this has been great. I think we tried to thread that needle between freaking people out and just giving them a way forward, though. So, thank you so much. I look forward to talking again. Thank you so much for listening to today's show. If you are looking for help turning your organization's great engineers into great managers, me and my team at Better Everyday Studios would love to help. We deliver targeted and interactive training workshops that are designed to help build the 3 fundamental skills of any new manager: building trust, giving feedback, and setting goals. Reach out to me through Matt at bettereverydaystudios.com so we can start making